So, council, let's just make sure, Mr. Gopal, you're watching the microphone here. So you're not killing tons ears. Okay.
Sorry about that, John.
That's okay. I did sign it.
For the record, John Goldfall, P 30758, on behalf of Mr. Casper. On the record.
My name is Philip James Cass.
Okay, and today's the date scheduled for the pre-trial on this matter in council.
Thank you. Yes, today is the time set for a pretrial. I've had an opportunity to review the files, also discuss this matter with the prosecuting attorney. Mr. Cass is originally charged with 1 count of high BAC, 1 count of operating while intoxicated, 3 counts of leaving the scene of an accident. He does have a valid driver's license, and I have discussed this matter with him. It's my understanding that in return for a plea of guilty to no operator's license on possession, the high BAC and the operating while intoxicated will be dismissed. It's also my understanding that in return for a plea of guilty to 2 counts, and I believe those counts are 3 and 4 of failing to report an accident, the lesser offense of leaving the scene of the accident. The 3 counts of leaving the scene of the accident will be dismissed. I've discussed with him his constitutional rights. I've also discussed with him the driving sanctions that would be operable with respect to this particular matter, and he wishes to avail himself of that opportunity.
Okay. Mr. Cass, please raise your right hand. I swear from the testimony about to give this hand, do the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. So you heard the plea that your attorney placed on record, correct?
Correct.
And as to the amended charge of operating while visibly impaired by alcohol, how do you plead? Sorry?
Guilty, Your Honor.
All right. And as to counts 3 and 4, leaving the scene of a property damage accident, how do you plead?
Your Honor, those are being dismissed, and it's failing to report. Next. The lesser offense.
Okay, all right, sorry, I misread that. It says 2 counts of fail to report, counts 3 and 4. So counts 3 and 4 are being amended to fail to report. Okay, let me clarify that in here. All right. Okay, as to the amended charges of on counts 3 and 4 of failure to report an accident, how do you plead?
Guilty, Your Honor.
You've gone over your rights with your attorney, correct?
That is correct, Your Honor.
And you understand that by entering into a plea, you'll be waiving some of those rights, specifically your trial and appellate rights.
That's correct, Your Honor.
And you also understand by entering into a plea, sir, the possible penalties as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
And knowing all that, you still want to continue with your plea.
That is correct, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
Yes, Your Honor.
All right, and counsel, if you can please voir dire your client.
Thank you. Mr. Cass, back on, I believe it was it the 6th or the 8th?
August 8th.
August 8th. On August 8th of 2023, were you in the city of Wyandotte?
That is correct.
And did there come a point in time prior to you that you were drinking alcohol?
Prior to.
On that date?
Yes.
And where were you drinking this alcohol, and what were you having?
Earlier in the day, I had a beer, maybe 2 at a friend's house.
Okay, and you had those 2 beers, or at least 2. Would that be a fair statement? Maybe 3 or 4?
I'd say at least 2.
Okay, and you left that location, is that correct?
That is correct.
And did there come a point in time where you left that location and you were heading home?
Correct.
And while you were driving home, did you strike at least 1 and possibly 2 automobiles?
It is possible. At the time, I truly thought it was a pothole, but yes, that is.
Okay. And when you got home, did you then consume more alcohol?
Yes, it was a very upsetting day, and I started drinking significantly more.
And what were you drinking significantly more while you were at home after you had operated remotely?
Specifically vodka.
Thank you. And while you were drinking before you got home and you had these accidents, was that those accidents because your driving ability was impaired due to alcohol?
I would argue that visibly impaired, correct.
Thank you. Your Honor, there's a breath test. I'm sorry, there's a blood test. However, there is some concern as to whether or not, based on his testimony and even the testimony of the officers, that the alcohol in his system prior to him being home was not as great as that was tested. That's why I asked those questions in that way. So your driving ability was impaired, is that correct?
That is correct.
And that was due to alcohol, is that correct?
Correct.
And you had these, now, did you report that you had those two accidents?
Unfortunately, I did not.
Defense is satisfied. There is a breath test, I'm sorry, there was a blood test, it was quite high, Your Honor, but as I've indicated, and we would stipulate that there was a blood test of 0.3, I believe. However, there's a question as to whether or not all of that alcohol was in his system while he was operating the motor. And it was clearly, obviously, even from his own testimony, 2 or 3 beers that he had would be greater than 0.4. Would you stipulate and agree to that?
I agree.
Is that yes or no?
I'm sorry, I agree, yes.
Okay, and you hit a number of cars apparently on your way.
2 cars, Your Honor, and it appears from the report, the one that's being dismissed was garbage cans, which then is a car,
Yes, that's true.
according to the police report.
All right, the court does find your plea as knowing, voluntary, and factually accurate. The court will accept your plea, the amended charge, dismiss the original charges per the plea agreement, and will schedule this matter for sentencing. Does that work for you, sir?
That's not a Saturday, is it? 'Cause I have a wedding
Okay.
right around that.
Well, sir, listen, I'm always available for warrants and whatnot, but not usually the docket on the
Okay.
weekends.
I
So-
I agree, Your Honor. I know I have a wedding I have to go to right around that time, and it's on a Saturday, so.
That's my son's wedding.
Okay, yeah, no, I will not be here on a Saturday.
14th should be fine, Rob.
That's a Thursday.
Yeah, that should be absolutely fine.
Okay. And
I'm sorry, you said what time?
9:15.
Thank you.
Right, and so you still have the alcohol tether on, correct?
That is correct, Your Honor.
All right, and if you were to test, what's in your system?
Absolutely nothing, Your Honor. I don't take any medications for any health reasons or recreational reasons.
Okay. Well, sir, I understand that perhaps your level wasn't a 0.33 when you were operating the vehicle. It was high enough that you hit a couple cars, trucks, what have you. So fortunately, nobody was injured or killed, nor yourself. We're going to continue your bonding conditions. And please stop at probation. Somebody will be with you shortly.
Okay,
Okay?
thank you, Ryan.
All right, have a good day. All right, we're going to be off the record. Okay, so we're going on the record in the matter of the City of Wyandotte versus Ryan Nicolau, 221384. And counsel, your appearance, please. Oh, where did Mr. Godwin go?
You left.
No, I'm attorney on the matter, so.
You want Johnny G?
Okay, do you want an attorney?
No, that's fine.
Okay.
I'll wait back.
All right, sorry about that. That was my whole picture, sorry. Sorry, time. Okay, so Mr. Nicolau, I know last time you indicated It was set for a restitution hearing because you indicated that you weren't going to be paying the court the fines and costs. However, restitution is something that's still owed. And then I believe that you questioned how the total amounted to $269.05, correct?
Yes.
Okay, so here's what's indicated for the police report, and this is what the court ordered, was the $269.05 as restitution. So there was a receipt attached at that time, and there's a copy of the receipt. Do you want to go over it, or do you want me just to do it on the record?
That's fine.
So it indicates a 12-pack of Simply Spiked lemonade of $17.99, bottle sales of $1.20, 19 Crimes Cali Red, $11.69, 19 Crimes Cabernet Sauvignon, $8.99, Ocean Spray Cranberry, 64 ounces, $5.99. There was 2 of those. Another 19 Crimes, $8.99, 19 Crimes Hard Chardonnay, $8.99, 19 Crimes, $8.99. There are also store coupons that reduced it by $1, so that's where the $8.99 came in. White Claw Ruby Grapefruit, 19 ounce, $3.49, bottle sales of 10 cents. White Claw Black Cherry, $3.49, bottle sales 10 cents. White Claw Mango, $2.99, bottle sales 10 cents. Smirnoff Ice, 6-pack, $10.99, bottle sales 60 cents. Blue Moon Light Sky, 6-pack, $8.99, bottle sales 60 cents. Vizzy Hard Variety Pack, $17.99, bottle sales $1.20. Apple and Lychee, 15.5 ounces, 22 of them at $2.79 each, $61.38. Miscellaneous beer, 17 at $2.89. Appears to be $49.13. Oh no, I'm sorry. That was, miscellaneous beer was $5.49. Monster Juice Punch, 17 of those at $2.89, it's $49.13. Ghost Energy Sour Patch Blue 4 at $2.89, $11.56. There's also bottle sales of $1.70 for the Monster Juice Punch, and the bottle sales of 40 cents for the Ghost Energy Sour Patch Blue. So that's $255.91, tax of $7.14, bottle sales of $6 gets to $269.05.
Is that restitution because they say they never got that back? Or that restitution is because I owe it just because they got everything on that list back? I was not able to leave the store with any of that. The girls register told me to go home after the incident took place, and they got every back. There was not one bottle that left the store with me that day. So was that restitution? Are they claiming they didn't get any of that back? I left work that day empty-handed. Videos that they have will show that.
So Mikloff left the merchandise behind. So it's possible that that amount was put forth for the dollar amount is to know how to charge this matter. So what the court will do is the court will waive the restitution. In the event that there's communication, I'm going to have my probation department contact the complaining witness, and in the event something is different from what the police report indicates, then we will bring this matter back up as a restitution hearing. But as of now, since it appears per the police report that you left out merchandise behind, which supports what you're indicating, then the court will indicate that the restitution amount is not owed.
My attorney had done did speak with the prosecutor about also them keeping my last paycheck. I did not receive my last paycheck, which isn't a big deal to me. I just wanted to address that too, that they still have probably $300. That's
Okay. I don't have any jurisdiction over that. So maybe that's something to speak to Mr. Godwin about, next time you speak with him.
I'm trying to address that.
Okay. All right. I wish you luck, sir. Off the record. Okay, we're going on the record in the matter of the state of Michigan versus Joe Parsons, 232001. And, Detective Sergeant, your name for the record, please.
Detective Sergeant Ken Grote.
All right, please raise your right hand.
I don't have to swear to this one, Your Honor.
Oh, yeah, no, you're correct, sorry. All right, and so, counsel, your appearance, please.
John Gold, P. 30758 on behalf of Ms. Parsons, for the purpose of this, investigation.
All right, Ms. Parsons, your name, please.
Jill Marie Parsons.
Okay, and counsel, as to the arraignment.
She's charged with domestic violence, second offense, Your Honor. It's a state case. I have discussed this matter with her. She will stand mute to the charge, waiver formally of those charges, and ask her to plead not guilty be entered on her case.
Court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, and we will schedule this matter for a pre-trial on September 7th. As Ms. Parsons already has another matter with us on that date, and it is scheduled for (10:15), so we'll keep this the same time.
Yeah.
Okay, and
She didn't have anything for August 10th.
maybe they're waiting for the warrant to come back. Okay, and so, Mr. Gopal?
Your Honor, it's my understanding that this was a domestic violence, that she does have a similar matter pending as the court has indicated, and that this is scheduled for with the same alleged victim. It's also my understanding, Your Honor, that there was bond conditions, and Ms. Parsons was allowed to stay in the marital home since that's where the children were, and Mr. Parsons had other means of where to stay. This incident allegedly occurred at the home. And we're asking that the bond that she's presently under be continued. There's allegations, obviously they're very serious, but which of course she denies having occurred. And as we all know, they're innocent until proven guilty. And I only say that because there are circumstances that work together. They are going through obviously some very trying times, trying to work out their relationship. With that said, Your Honor, we're asking that the bond, and I don't know what those bond was, be continued and to continue those under those circumstances.
Okay. And Detective Sergeant Grote, as to bond.
Your Honor, it's our understanding the victim in the case resides in South Rockwood in a trailer. He only stays sometimes on the 2nd Street house. Ms. Parson, I believe, has some addiction problems that she probably needs to work on. A low cash bond is fine with us. I don't know if the victim in the case was a little hesitant on following through with charges, but then he changed his mind and decided to follow through with charges.
Okay, Ms. Parsons, you are currently out on bond in this court for a domestic violence, correct?
Correct. Yes,
And who's the complaining witness in that matter?
my husband.
The same individual that's the complaining witness in this matter?
Yes. And he's not pressing charges in the first matter either.
Ma'am,
Yes.
we're not at that point. As of
Okay.
now, those charges are pending,
Okay.
and You also were bound over to the Third Circuit Court for felony possession charges, which apparently were resolved, and you're on 3 years probation, correct?
Correct.
And, thank you, what happened in E-course?
I'm not sure. The what?
Back in April.
I'm not sure. I don't remember. I'm sorry.
Okay, so your matter. How often does Mr. Parsons stay at the home on Second Street?
He's not supposed to be staying there as of right now
Why not?
because of our first domestic. I'm supposed to be there with the kids. He's staying at our trailer in South Rockwood.
Ma'am, that was not my question.
Oh,
My
okay.
question to you was, how often does he stay at the home on Second Street?
Every night.
Okay. And how old is your daughter?
16.
And it's alleged in both cases, so the June 16th matter that's coming back September 7th, that's also a second offense notice, and since that matter hasn't been concluded, this one is a second offense.
Your Honor, I saw that in reviewing the file, and it indicated it appears that you did have a domestic out of the 33rd, but the date, and I'm sure it was a misprint, said October of 23.
No, I showed 2013 on both of these.
Oh, okay, the document I did see showed that.
Well, hold on, let me look.
I understand, Your Honor, and I knew there was one out of turn. It's on the last page there.
Ma'am, if you were to test what's in your system,
Nothing right now.
what's that?
Nothing right now.
Okay, well,
I can
Yesterday
tell
would be
you, there's
before.
nothing in my system.
and then this is, you also have a chart, are you currently on probate? No. What happened on your smuggling charge? You're furnishing contraband to prisoners.
I don't know what that one is. When was the date on that one?
It appears, so it occurred in 2014, but it appears as though it wasn't resolved until 2021.
I have no idea.
Do you work, ma'am?
For my husband's company,
Which is what kind of company? I don't know what that is.
Terry work at his industrial maintenance company.
And why did you answer this document that you do not have a job?
Cause I don't right now. I haven't been working for him for the last 2 weeks.
Okay, I think I just asked your client if she works,
Correct.
and she said yes.
Yes, but she,
But here she answered no.
I understand that.
On this document that says the felony to intentionally submit false information to a court.
She indicated that because, Your Honor, she hasn't been working there for the last couple of weeks, as she just indicated. So therefore.
So then she's
I
not
guess-
working,
I guess in her mind, she's not working at this point in time.
but
Yes,
she answered yes that she was.
I understand that, Your Honor. It was probably a mistake on her. Not any attempt to defraud the court. We're just talking about who's paying who's working for her husband's company.
And ma'am, the detective mentioned something about eviction or housing.
No, I don't think so.
Totally not Matt.
Oh, that Matt's not living at the house, no. My husband's not living at the house right now,
He just stays there every night.
pretty much. I know.
I guess that would be a matter of interpretation, but that sounds to me as though he lives there, if he stays there every
Well,
night.
I agree, Your Honor. However, I think that what she indicated was that when she was here on the previous domestic, there was to be no contact, obviously. And because she was the primary caretaker for the children and he had another place to go, she was allowed to stay in the marital home while he was residing in, Rockwood. He's been showing up there and staying at the home as she's indicated, but as far as eviction is concerned, I don't think that was ever mentioned. Only that he's not supposed to be there, but she's the one that's under charges, so he's been visiting, and I was reading the report, was visiting with the child or one of the children.
Okay, but the order indicates for Ms. Parsons to not have or cause any third party to have any direct or indirect contact with the following person, that being Matthew Wayne Parsons. And she was not to enter the home on 2nd Street. The bond condition is, ma'am, you're not even allowed to be at the home.
Correct. I don't have anywhere else to go.
Ma'am, the court order from the reigning judicial officer, which was not this court, it appears to have been Magistrate Boyer. You were given a $10,000 personal bond, and you were instructed not to return to the home on 2nd Street.
Correct.
Yet, you went back to the home on 2nd Street, and that's where you've been living,
Right.
and you have a pending domestic violence second offense charge that you're out on bond for, and now you have the exact same charge.
Correct. I know.
What is it you know?
It's messed up. And this whole situation's messed up. I should at least be able to go in the home with my children. He doesn't have any children that live with us. I should at least be in the home with our children. So, I mean, he's got plenty of places to go. He can stay at our shop, he can stay at our boat, at our trailer, he can stay everywhere, and I've got nowhere else to go with our children. I should be able to be in the home with the children. He's the source of our income.
Excuse me, why is it that you think you should be in the home with the children?
Because I have nowhere else to go with the children. He's got multiple places to go by himself. He's the source of our income. He's the owner of the company that I work for. He's the source of the income. He's got multiple places he can go stay. He's got our trailer, our boat. He's got our shop that he can go stay at. I can't take the children there, whether, I can't take them there when they go back to school and stuff. I can't be living in a trailer with them or at our boat with them. He can do all that.
Except I believe it's alleged that the children are home when these incidents occur, correct?
No, they were not home.
No, for any of
The
these
first
alleged
incident,
incidents.
his daughter, by first incident, my daughter was at home. The second incident, none of them were home.
And both incidents alleged items being thrown at Mr. Parsons.
I don't know about that.
Okay. Well, you also seem to have something pending out of the 25th District Court, or at least a warrant pending, charges pending. And then also, August 10th of this year, were you arrested for drugs, ma'am?
It was a prescription that I didn't have in a prescription bottle.
The case is still pending, Your Honor.
Okay, so ma'am, you were arrested yet again on something else.
Yes,
Okay, well, it seems as though you have a hard time understanding the court orders. Given the fact that you are currently on probation for felony possession charges downtown that you were bound over for from this court, the fact that you are currently out on bond on charges that are exactly the same charges that you're currently in front of this court for, there is a pending charge apparently for felony drugs. You were ordered not to have any contact with Mr. Parsons, nor to return to the home, and you just have the mindset of, oh, well, I have nowhere else to go, so I'm going to disregard the court order and I'm going to return to the home.
no, ma'am, I don't
The
think
court
that.
Well, ma'am, your actions would suggest differently as well as what your statement was. The court's going to indicate
Sorry.
a $25,000 10% bond with the following bond conditions.
2,500.
The court's going to also indicate another basis for that bond is for the protection of Mr. Parsons and society. You are not to have any contact with Matthew Parsons. That's phone contact, direct contact, social media, third party, anything of the like.
Okay,
You're not to enter the premises on 2nd Street.
okay,
With the exception of one visit to obtain personal belongings accompanied by a police officer. So what that means, ma'am, what that means is you go to the police department, then you go to the home with an officer. You don't go to the home and then wait for an officer to arrive.
okay,
Am I
Okay.
keeping you up?
no,
You're not to possess or consume any alcohol or drugs unless prescribed. You're not to have any access or possession of any firearms and or any weapons. And you're also to have a GPS tethered through the Wayne County Jail. Therefore, if you go to the home on 2nd Street, which will be an exclusion zone, you will be arrested, ma'am.
okay,
You keep saying okay, but you're continuously violating the court's orders. You've been violating the bond order.
well, I'm gonna have a feather on, so I'm not gonna be able to violate.
Do not interrupt me, please.
I'm sorry, I didn't mean to.
You've been violating the court's bond order. It appears to be consistently since you were arraigned in June,
Hey.
just because you had nowhere else to go. So, oh wow, I'm just going to stay here anyway, despite the court telling me no. And the court's going to also indicate you to participate in random drug and alcohol testing in the event you post bond.
I'm not gonna be able to postpone.
What's that, ma'am?
I was just saying, I'm not gonna be able to post bond.
Okay. Anything else, counsel?
No, Your Honor, thank you.
All right, thank you.
Your Honor, I will answer this question. I do understand the court orders. The court orders, I wasn't here for the original arraignment. But if the husband, Mr. Parsons, agrees that he would give her custody for the duration of the marital home, then would she be allowed to return there with his understanding that that's where she will be and he has other places to stay? I understand what the court is saying.
At this point, counsel,
But
that's something we can readdress on September 7th potentially, but,
it appears to me, Your Honor, if I may, that and I understand the court's orders, but Mr. Parsons also should be held accountable. I understand he's the victim, don't get me wrong, and we go through this all the time. That, and I, again, was not here presently at the first time, but normally,
Neither was I, it was about county.
I understand, Tony. Normally, that would have been, under those circumstances, no assaultive conduct. She would be allowed, I mean, from what I'm getting from this situation, she has children. She has, the only place she can be is at this marital home. The children, and I don't know if they have children together or, but based on the age and their length of marriage, I have a feeling that at least the daughter is her child. I could be wrong. And it should be one of no assaultive conduct. I'm only asking that she be allowed to go there and just don't assault her husband. Now, I know this is a second one with a second allegation. But again, we are innocent until proven guilty, as the court is, well aware. And I would only ask that it be no assaultive conduct, so she has some place to go if she's able to make this fine.
Ms. Parsons, who's the complaining witness in the matter on your first domestic violence?
My
Ms.
husband,
Parsons?
yes,
Counsel, I understand that your client's innocent until proven guilty. However, the court, in taking into consideration the totality of the circumstances, with now 2 domestic violence second offense charges, I have zero confidence that your client will not be assaultive. Zero confidence. Further, while you acknowledge that Mr. Parsons is the victim in this matter, you also indicate that he has some accountability here as well. I will note that if it were reversed and Mr. Parsons were in custody and Ms. Parsons were not, I don't know that there would necessarily be the same school of thought.
well,
Yes, ma'am.
the reason why it's not vice versa is because I didn't call the police first. Because I didn't call him on him. I got a shiner too on my side of my eye, but I didn't call him on him.
And Your Honor, you indicated they might be reversed. I don't know, but I would also be making the same argument if those circumstances were similar. No assaultive conduct. Again, neither of us were at the first one. We're now here at the second one.
I agree. It will also indicate that in both reports, it's alleged that there were items and objects that were also hurled at Mr. Parsons, and not just Ms. Parsons physically touching him. I should say not only her physically touching him.
And I think that's the first report, but I did review this report, which she does.
Yes. Ms. Parsons was informed specifically not to return to the home on 2nd Street. She didn't ask for a modification of bond. She didn't ask for anything. Quite frankly, she failed to appear on June 29th when she should have been present for her pretrial. And Ms. Parsons has exhibited thus far a complete and total disregard for court orders.
And again, Your Honor, I wasn't present on either of those occasions. I'm just bringing this to the court's attention.
No, I agree.
And I would have been arguing back the first time for no assaultive conduct.
Correct. Although I don't know that Ms. Parsons is able to control her emotions enough to follow no assaultive contact. She can't even follow the court order to not return to the home where she's continuously resided since
And Your
she
Honor,
was released from custody the first time.
I'm not going to continue the argument. I understand the court's position. There's a difference between returning to the home to take care of the children, to take care of the family, as opposed to not controlling her aggressively.
I understand that, but look what she's charged with again.
I understand, Your Honor.
So the court's order is what is its order.
Sure.
And Ma'am, you're not to call him from jail, you're not to call him on the phone, you're not to have anybody else contact him.
Okay,
Is that clear?
yes,
Your Honor, I believe that because I'm just bringing this to the board's attention, if he's the sole provider, excuse me, then, and he's got the children there, he's gonna make sure that she's not gonna be there. However, I believe that since he has control of the purse strings and you're asking for a bond, she should at least be able to contact him or through somebody to see what about bond. You've ordered, issued 25,000, 10%, which means she has to come up with, you said 25,000, correct, or 2,500?
25,000,
So
10%.
she needs $2,500. So I think that she should at least be able to contact him either directly or indirectly to find out if he's gonna be able to post bond or provide her with some money to post bond.
First of all, I am not going to allow her to contact him directly.
Right.
Because if I were to allow her to contact him directly and discuss only bond, I have zero confidence that she's going to follow this court's order. Second of all, you are wanting this court to allow her to contact the victim in this matter, the victim in 2 cases, who is also a victim in another matter, to post her bond.
Or provide it. She said she works for the family company. She hasn't worked in a couple of weeks. She therefore has no income that has come in, so she can post bond. Yes, I am asking that.
Well, she should maybe be able to contact some other family members. She's not, there's no contact with Mr. Parsons.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
thank you.
Thank you.
Parsons.
Off the record.